Welcome to assignment 2. For our case study comparison, we elected to focus on instances where teachers were accused of being negligent in their duties. We felt that it was important to continue our investigation in the area of teacher negligence, as this is one of the areas of case law which remains the most unpredictable. To further narrow the scope of our investigation, we chose to highlight cases where teachers were accused of negligence for events that occurred predominantly outside of the traditional classroom environment. It is important to us, as future teachers, to understand the complexities involved in the cases charged with determining teacher negligence, especially in the case of supervision of students outside of the traditional classroom environment, as we, in the future, may be tasked with similar responsibilities. Negligence by teachers falls under tort law of unintentional harm to another caused by a failure to act. Under tort law, the plaintiff must prove the elements of negligence through a balance of probabilities. In this case, the ruling of negligence must involve 5 overarching aspects. There must be a duty of care between the defendant and the injured party. There must be a standard of care which is expected of the person in a position of power. For teachers, this is the care of a prudent parent standard. There must be a breach in the standard of care. There must be causation. That is, a failure to act according to the standard of care must be proven as a direct cause of the injury sustained. And finally, there must be damages that were reasonably foreseeable. For a ruling of negligence to be upheld, the court must first define the standard of care expected of teachers in the supervision of their students. The educator's standard of care was first established in 1893 with the case of Williams v. Eadie. More recently, in 1981, Supreme Court of Canada case of Myers v. Peel County Board of Education has become the precedent case law for the definition of the care of a prudent parent. The complexity of the definition for the prudent parent is highlighted in this case with the statement that standard of care cannot be applied in the same way to each case. Its application will vary from case to case and will depend upon the number of students being supervised at any given time, the nature of the exercise or activity in progress, the age and the degree of skill and training which the students may have received in connection to such activity, the nature and condition of the equipment in use at the time, the competency and capacity of the students involved, and a host of other matters which may be widely varied, but which, in a given case, may affect the application of the prudent parent standard to the conduct of the school authority in the circumstances. In recent years, tragic accidents occurring under teacher supervision have seen the issues of teacher negligence move into mainstream media and conversation. One incident that received a significant amount of media attention was the 2017 drowning of Jeremiah Perry during a field trip to Algonquin Provincial Park. In July 2018, the supervising teacher, Nicholas Mills, was formally charged by the Ontario Provincial Police with criminal negligence. If asked whether or not the teacher exhibited negligence due to the breach of his standard of care for Jeremiah, we would direct the reader to the 1972 Ontario High Court of Justice case of Mahjong et al. V. Huron County Board of Education et al. During an overnight field trip, a group of students convinced the defendant to allow them to swim in an area created by the Conservation Authority. While the area close to shore was shallow, there was an unmarked sharp drop-off further into the water, which the defendant warned students to stay far away from. When a surface current pulled 2 students off the drop-off area into the deep water, a third student immediately swam out to their aid. While successful in rescuing the first student, the student drowned in an attempt to save the second student, who also drowned. The ruling of negligence in this case sets the precedent that Nicholas Mills would be found negligent in the drowning of Jeremiah Perry. Further, this case sets the precedent that when the negligence of a teacher exposes a student to certain dangers, there may be foreseeable risk that a third person may attempt to aid the injured individual, and that there is a chain of causation started by the initial negligent act. In this case, the defendant was found to be negligent in the death of both students. Within school grounds, students are often injured due to physical altercations with other students. In many cases, allegations of negligence due to insufficient teacher supervision often follow. In the 2013 Ontario Superior Court of Justice case of Patrick v. St. Clair Catholic District School Board, the ruling judge found both the school board and supervising teachers non-negligent in their duties of supervision for an incident in which a student suffered a brain injury during an altercation with another student prior to the first bout. The ruling was based on the fact that the incident was sudden and unexpected and could not have been anticipated as reasonably foreseeable. In addition, it was ruled that the level of supervision for the outdoor area was sufficient and reasonable. Similarly, in the 1990 Ontario Provincial Court case of Mainville v. Ottawa Board of Education, the school board was found non-negligent in the injury of a student caused by a thrown snowball while leaving school. Despite the fact that no teachers were assigned supervision duty of the school grounds at this time, the ruling held that the supervision and protection of students is based on that of the prudent parent, and that it is reasonable to assume the act of leaving school does not represent a dangerous act. Further, it was stated that students were generally known to throw snowballs, and that it does not fall under the responsibility of the school to stop such actions. No amount of supervision could have stopped a student from throwing snowballs at the plaintiff. In the 2003 Ontario Superior Court of Justice case of Lee v. Toronto District School Board AL, a grade 2 student suffered a significant brain injury due to the violent actions of another student. The plaintiff claimed that the school board and teachers were negligent in their duties, failing to prevent the injury-causing assault. Despite ruling that the injury was a direct result of the violent incident, the school and its staff were found to be non-negligent, as it could not be proven that the standard of care was breached and that additional staff members supervising the schoolyard would have prevented the sudden and instantaneous event during regular schoolyard play. Within the 2019 Ontario Superior Court of Justice case of Deborah Tilley v. Hamilton Wentworth Catholic District School Board AL, the plaintiff claimed that the school board was vicariously liable for an injury sustained by the plaintiff during a 3-minute class transition period in the hallway. Their claim was that the board was negligent due to inadequate supervision during this transition period, which fell below the standard of care expected from a prudent parent. The judge found the board to be non-negligent in the injury, as the standard of care for 15-year-old students with no predisposition for violence does not include constant supervision. Furthermore, it was stated that as the event escalated and finished within a 30 to 45 second period, only by posing a teacher in that exact location and at exact time would there have been any possibility of action. While the case law suggests that teachers and school boards are not often held vicariously liable in student-to-student injury, the United Church of Canada and Her Majesty the Queen were held vicariously liable in the 2001 case of Blackwater v. Plint for the sexual assaults of students within a BC First Nations residential school, as committed by one of the school's teachers. In addition to off-campus field trips and schoolyard injuries, students are also often injured outside of the traditional classroom in extracurricular sports activities and while in physical education cases. The 1981 Myers v. Peel County Board of Education case, the case of McKay v. Board of Govan School, in 1967 found that a supervising teacher was not liable for an injury sustained by a student in a gymnastics accident due to the School Act of Saskatchewan, containing provisions that teachers responsible for the conduct of pupils will not be held liable for personal injuries sustained in events where the principal of the school approved or sponsored the activities. However, the jury did find that the school board failed in its duty of care to the student and was therefore vicariously liable for the resulting injury. In the case of Peters v. Peel District School Board and Thomas et al. V. Board of Education of the City of Hamilton et al. From 2016 and 1994 respectively, teachers responsible for the supervision of students who were injured during extracurricular sports were found to be non-negligent in their duty of care under the care of a prudent parent definition via Myers v. Peel County Board of Education. In the former case, the teacher was found to have not only compiled the OFIA safety guidelines for supervision, but that the standard of care for a prudent parent was upheld on multiple accounts during the time in which any injury was sustained during a long jump exercise. Within the latter case, an injury sustained while making a tackle during a high school football game was deemed on initial trial to be within the limits of risk inherent to a contact sport. Within the appeal, the judge reiterated the findings and claimed that both the appellant and his mother had consented to the normal risks of the game. While the case of McKay v. Board of Government Schools used the arguments that the plaintiffs had not been provided the proper training and skills to be attempting maneuvers on parallel bars, especially so with an unqualified teacher, it was the board who was ultimately found liable. However, in the case of Husak v. Chilliwack School District Number 33, the same argument of not providing students with the necessary skills to participate within a particular sport was used to find a supervising PE teacher guilty of negligence due to a breach of his standard of care for an injured student. In this case, a 13-year-old boy was hit in the face with a field hockey stick, leading to the development of a serious somatoform disorder. Having examined the level of complexity for negligence rulings on the part of the teacher due to breaches in the standard of care expected for students under the precedence of the Myers v. Peel County Board of Education, it leaves behind a question for the future of teacher negligence cases. In particular, it raises the question of how will negligence be defined within the online learning environment as the province of Ontario moves to make online learning a mandatory part of secondary school education. Within the online learning environment, what will the definition of the prudent parent become? When will the teacher be responsible for their students and their actions? In the 2011 case of Gallant v. Thames Valley District School Board, a teacher was accused of being negligent in her supervision and treatment of a student who ultimately took their own life. In the electronic email submission of an assignment, the student was said to have began the assignment's essays with, "I just want to kill myself. I want it to be painless. I don't have access to a gun, so the next best way would seem to be to hang myself." The defendants argued that the teacher, upon reading the essay, should have contacted the parents immediately. Within the case, the duty of care was referred to the 1993 case of Bain v. Calgary Board of Education. The board ruled that the teacher showed no proof of her discharge of the duty of care to take care for the safety of the student. Thus, the ruling of her negligence would be determined on evidentiary record. The case of Gallant v. Thames Valley District School Board raises the question of how potential disclosures or troubling behavior exhibited by a student in an online learning environment or an email sent during non-business hours would come into play for negligence accusations. Does there need to be legislation or rules in place outlining when teachers must be in contact with their email? Or do teachers now have a duty to report at all hours of the night and day due to the accessibility of electronic communications in online learning environments? I will now take a moment to pause on the reference slides, as there are quite a few there. Thank you for listening to our presentation.